as you saw, okay, got it. Thank you. As you have seen, I'll be hosting this, and I've had a couple of guests come along now. My first guest, which we're very lucky to have him here today, is very busy young barrister Luke Perilli, who is a barrister at the Victorian Bar. Before that, he was a lawyer for Morris Blackburn, Shine, just to name a couple of firms, predominantly working in the plaintiff field, but also dabbling in the defendant area and over personal injury and other practice areas. So Luke, if you can wave and say hello.
G'day guys, thanks Kurt.
So Luke, I think just to start off, just besides my introduction, maybe just tell us a little bit about yourself.
Yeah, sure. I came to the bar, I think it might have been May of this year, March or sorry, I did the readers course in March, I believe, and signed the bar role in May. Prior to that, I'd worked as a solicitor for 5 years, as Kurt said, across injuries litigation. So there was a number of different areas of injuries litigation that I've done. And in the process of doing that, I realised that going to court and preparing court documents and doing anything in relation to court was effectively what I wanted to do. So I essentially made the move to become a barrister, and I've been here for a couple of months now, and enjoying it, and doing obviously everything that's litigated.
So the way this session is going to work today is we got Luke for 15 minutes because he has a meeting that he has to go to straight after this. So what we'll do is we'll hear from Luke and his experiences of being a barrister and essentially spending nearly every day in court, whether it be the Magistrates Court, County Court, Supreme Court, in VCAT. If I forgot any of the courts, Luke, maybe you've gone to the Family Court. So we'll hear his first-hand experience about being a barrister and advocate every day. And then after that, we'll move on to giving some tips. I'll introduce my second guest, who's Mark Andriacchio, a past VU student. And I'll give him an introduction later on, but that's when we'll go into the crux of what's involved in providing a court appearance, bringing a submission forward to the court, as well as tips for moots, which is also an important part of your university education. Now, Luke, let's start off first of all. As a barrister, what would you perceive to be the number one thing, or the number one element of providing or giving a submission to the court?
I think the number one element is confidence. You need to have confidence with the submission that you are making, that submission is the right submission. So just to expand on it, there are a lot of egos in the legal industry, right? Because we're obviously dealing with, and I think we've all heard it, for you to get into law and to study law and to get through university and then find a job as a lawyer and succeed in that job, you obviously have to be someone that has had quite a bit of success and is naturally a high achiever. So I think that's something that law students and people that become lawyers and barristers, they naturally have that ability within themselves that yet they can get the job done. And not so much that they are right, they're always right and they're never wrong, but they certainly have confidence is what I'm trying to get at. So when you are making a submission, whether it's in a moot or in a real court case, there's obviously an ultimate goal that you want to reach, whether that is a particular judgment, whether or not you've got a client that is guilty or not guilty and you want to get them off, or you want to prove that they're guilty and you're trying to make a submission, for example, or even let's say a parking ticket case where somebody's been, to put it real simply, fined with a parking ticket and you want to get off, you need to put your submission to the court. You need to be confident that what you are saying is right, because judges feed off the people that are before them. Remember, judges are, it can be a really lonely job when you are on the bench by yourself, because more often than not, they were solicitors or they were barristers that were in a very big collegiate environment. So they are alone for a great deal of the day, and they feed off the energy that people before them bring. So in circumstances where you're making a submission, if you are confident when you're speaking and you are explaining to the judge and talking in a manner that you understand. You're telling he or she that whether you're right or wrong, that you understand what you're talking about and that what you are saying is correct. They will really appreciate that, feed off that confidence, and potentially even grant you your order. And it may even be something that is completely wrong. For example, it may be a parking ticket that, or for example, I'll give you a really simple situation of a car accident case where somebody hits someone, and one party is clearly at fault. You might be acting for the other party that has hit the car. And for your client to get off this case, you're going to have to make some sort of submission in a very confident way, whereby you're saying, look, this is what actually happened, Your Honour, and this is what you need to find. So I would say, Kurt, number one is being confident.
Thank you, Luke. Now, in relation to being in court, what's the most important thing to do if you're not speaking in court?
Oh, you need to be, well, first you need to be courteous. It's different now when we're on Zoom. If you're not speaking in Zoom now, you just put your your microphone on mute. So that's the number one thing you do. But if you're in court, you certainly don't speak. And you don't speak unless spoken to. So your opponent may be making the most outrageous submission, for example, a car accident claim. And let's say you're acting for the guy that's clearly been hit by a car. Well, his car has clearly been rear-ended by another car. And if you're acting for the person that's been hit, it's a pretty clear-cut case that you're probably going to be successful if the evidence falls your way. But if the other person, the other barrister, goes ahead and makes submissions that, no, Your Honour, the accident didn't happen in those circumstances. It happened in completely different circumstances. And my friend here, the plaintiff, actually did a U-turn and hit me. And so the story is completely different to the story you're trying to advance. You might be really annoyed by that, but you just need to let it go and make a note, because you have to make notes when they're talking so you can figure out the points that you're going to rebut them on. And certainly in those circumstances, be courteous, keep it to yourself. Don't react. That's another thing. Don't actually react. If he might make a comment, you might pull a face. Don't do that. Just poker faces the whole time, whether it's, and being really kind as well. I mean, kind with your facial expressions as well, smiling, but you don't need to, don't laugh or don't do anything to sort of annoy the other side or just sort of belittle them at all. Just, calm face the whole time, regardless of whether or not they say the person hit me or I hit them or whatever it is. Don't say anything.
Thanks, Luke. Now, when you're preparing to do a submission for court, how do you go about preparing?
Oh, that's a tough one, Kurt, because there's so many different facets of it. Firstly, you've got to read the material. You need to get across that material. Let's say it's a moot or a court hearing. No matter how long, you're going to get a brief of some sort. You need to be across it completely. You need to understand both sides of the case. And then at that point, just think about, well, the first thing that we are all taught as barristers is preparing a case plan, right? A case plan is how you are going to run this case, how you're going to get to the submissions that you're ultimately going to make. And your ultimate submission might be, this accident happened because vehicle B hit vehicle A and I act for vehicle A. Well, you can't just essentially make that submission. You need to get through the facts and understand how the evidence plays out and intertwine the evidence into those facts to say, okay, well, Your Honour, because I've told you this, this, and this, and because you heard from witness P that told you this, this, and this, you've also seen a report that shows this, and you've also seen this, and you've gathered all the evidence together. Your Honour, on the basis of all this evidence, B had to have hit A, and there was no other way that this accident could have happened. So in answer to the question, getting across the material, understanding the material, drawing a chronology, set out a chronology. This is what happened first. This is what happened second, and in your own mind. And then if there's a little bit of a dispute, let's say, for example, the car B says, oh, I didn't hit car A, and then car A, or there's a different version of events in terms of timing. You just make a note of that and you deal with that in your own, in your submissions. But certainly prepare the chronology, get across the material, think about the evidence, and think about what your final point is going to be. That's how you're going to get it in a short answer to that question. There's a lot of work involved though.
And for those who are less inclined to be advocates,
Hmm.
so for example, instructors, what's the best thing they can do for counsel to ensure they provide the best advocacy?
Well, they need to actually be across the file more than anyone in it, everyone really. It's the solicitor's file. The client goes to the person who has had the car accident or has stolen whatever it is. They go to the solicitor first, but that's their first port of call. So you need to be completely across the file. If you are the instructing solicitor, your role is just as important. You need to make sure that the file is in order. You need to make sure that when the witnesses are called, they're going to be available. You need to essentially give the barrister, you need to guide the barrister through the case and guide them and provide your input. Provide your input in that. Talk about the strategy. It's not their case. It's not the barrister's case. It's not my case. It's the client's case. And it's actually the solicitor's case to put as well. So certainly the solicitors need to be across the file. That's first and foremost. And make sure the evidence is in order. There's a barrister can't just come in and call whatever evidence he or she pleases. There needs to be a basis for that evidence. And usually that evidence is within the brief. So, and who prepares the brief? The solicitor does. So, yeah, the solicitor's got a very important role, and as you'd even, from our experiences, being across everything and having your own view on it as well, form a view, and it's not just a barrister's case. Like I said, you've got the solicitor's got a view, and more often than not, that's a pretty strong view on it, and it's important that the parties respect one another about that.
Yep. Now, in relation to being in court, how do you handle questions from a judge or a magistrate?
Oh, I think the first thing, well, depends on the question, but more often than not, you might be caught off guard. And one process that I take is, well, firstly, don't cut them off. So listen to the question. Mr. Perilli, can you just explain this, and this? For example, whatever the question is. I might not understand the question. I might be so nervous that I don't understand the question. It happens to everyone. Your Honour, could you just please repeat the question? I'm sorry, I didn't quite catch that. If you're on Zoom, that's okay. My internet cut out. But in court, that's a little bit harder. You just need to think about the words that are being said to you. I'd take a deep breath if it's a question that you might need a little bit of time to answer. If you can't answer the question, Your Honour, I'll take that question on notice. You're obviously not able to answer it, or my instructor, I don't have those instructions, or there's usually a way around it if you don't know the answer, of course. But certainly wait for the question to be asked. And sometimes the judge may frame a question in a really long way and say, okay, Mr. Perilli, so what you're saying is vehicle B hit vehicle A. Is that true? And there might be an opportunity for me to say yes or no. But they might actually add to that and say, well, if it is true, what my view is this. Now, what do you say about this? And you sort of got to think about everything that's being said, write down the topic that they're talking about. And while they're asking you the question, just say, okay, well, he or she, they're asking me about this, so I'll write down that's that part. And I want to raise this point, this point, and this point. And when the judge finally finishes the question, which might be sometimes a couple of minutes long, you can form your answer pretty easily.
Now, one final question. So I'm just mindful of the time.
No, that's okay. That's all right.
Think back to your first day in court, whether that was as an instructor, well, not as a solicitor, but doing an appearance. Or was your first day as a barrister in court?
Yeah.
Obviously, everyone has their first day. Yeah. What was your tactic to, get over the nerves, if any nerves, because then you have nerves of steel, but how did you get over those nerves?
Yeah, I'll give you two experiences. I had an appearance as a law student when I was at a community legal service. I used to do volunteering at a community legal service as a paralegal, and I did an appearance at a magistrate's court in Heidelberg for it might have been a parking ticket or something like that. And at that point, I had not really ever been to court. You go watching and you see what it's like, but I didn't know anything, didn't know anybody in Heidelberg. It was a really empty courtroom. So I was really excited to make the appearance. I really wanted to. I couldn't sleep the night before, and I made the appearance and got the order, and I was absolutely stoked. But then I started as a lawyer, let's say as a graduate lawyer, and I started going to court more often and seeing what it was like. And I actually got more nervous. And then I remember making my first appearance as a solicitor. I felt more nervous than I did as a law student, because remember, I've become a lawyer, finished my law degree. So I've gone through all that. I'm going to get admitted. I'm almost there. I don't want to stuff anything up. And, this could be the end of me. So I was incredibly nervous. But the one way I got around it was talking to people that had done the same thing. Talking to people that had been before that exact same judge. For example, with a case like when you do have to go to court, you're going about a case of some sort, right? And as a trainee lawyer, it wasn't my case. It was another solicitor's case. And I was helping he or she with that case, right? And so, I'd ask them about the case and make sure I was across the case and made sure I knew what they wanted out of me. I'd speak to people from my office that had been before that exact same judge and understood what that judge was like. I spoke to the opposing solicitor beforehand to make sure that we're all on the same page. If it's a very contentious issue, that's going to be difficult. But I sort of had a feel for what it was like before I got in there. By the time I was before the judge, I knew what was going to happen. I was incredibly nervous. I'll never forget it. And I knew how that judge was going to react. And I think I didn't answer a few questions here or there, but they I don't know what it is, but they actually know if it's your first one. They can tell. They can just tell, because if it's someone's first time before in court, they know. But yeah, a lot of nerves, taking deep breaths, making sure you're across it, but also speaking to people. Even now, if I've got a case or have to go before a judge, I'll always ask people, what do you I had one the other week actually before a judge that was just starting at the courts. I didn't know how they were going to be. I actually watched a YouTube clip of them. They were a lawyer at Slater and Gordon, and I had a look at the YouTube video, and I thought, oh no, he seems like a really nice guy, and he was. So, but it's a lot easier on Zoom because the nerves aren't there because you're not in a packed room. But I get nervous every single time. Yeah.
Alrighty. Well, Luke, thank you very much for your time. Well, we've got a question here.
Yeah.
Quickly, we might answer this one. What is the best way of well, the question has disappeared on me. What is the best way of obtaining an opportunity to volunteer as a law student? And that's from D. Fitzsimmons. So thank you for your question.
As a way of volunteering as a law student, we have these great things called community legal centres. We've got the Federation, the National Association of Community Legal Services, I think, NACLAC. And that was some of my best experiences as a law student. We're in those places. So wherever you live, wherever your region is, you can go on this, the National Community Legal Service hotline website and have a look and see what opportunities there are available. More often than not, those volunteering services will take people on because they need hands. Remember, it's free, so you're doing them a favour by getting on board, and you're certainly able to assist, and they're able to assist you. So I'll just sort of look at which ones are local around you. For example, you may live in the western suburbs, and there are ones in the western suburbs, the southeastern suburbs, and you get Frankston, Moreton. There's so many different areas. So I'd certainly look at that. That's a great volunteer way. Other ways are, you can speak to barristers. That you might reach out to a barrister that you think you might want to volunteer for and say, look, hey, I'd really like to just shadow you. It's a bit tough now because of this whole COVID thing. But I'd love to shadow you and just follow you around and things that they might seem weird. But what's the best way to learn? Or otherwise, just contacting random firms and just saying, look, I'm a law student, I'm wanting to get my name out there. I always felt that contacting random firms didn't really get me too far. I think because it's more about if there's an opportunity, and community legal services take on cases that, that they know that there are resources and students can, get involved. They're not taking on high court appeals. They're taking on really simple cases that you can certainly get your hands into. So get out there. As a first year, what are my opportunities? There's still a bit. I got involved in my first or second year. Again, it's contact community legal services. Say I'm a law student willing to get out there. You can contact barristers. A lot of barristers need research done. contact barristers and say, look, hey, I'm willing to do some research for you. I think the firms are a little bit more difficult. But yeah, some people may know people that work at firms, and that may be an opportunity. I didn't know anyone that worked at any firm. So I was just more looking at community legal services. That was where I really found my that's what I wanted to do, and that's what I love. So there's certainly opportunities. You just got to get out there. I think the Leo Cousins or the College of Law website, one of them, there's always advertisements for law student positions. So just put your name out there and you'll be fine.
Well, I just want to say what Luke said there is getting experience with a barrister, just asking, is great. And that's how I started my foot in the door in the legal world. I asked before I even started law school to just get some work experience with a QC barrister. And for some reason he said yes, and I ended up working with him as an assistant for 5 years, and then that led into my graduate role at Slater's, and then to become a lawyer at Slater and Gordon. So, and I think Mark would have the same experience. You know, you're just not so much of a barrister, but you have the same experience. You take all your opportunities, and you just got to put yourself out there. I think Mark's role, he got through a program through the uni.
Yes. So that's right. So I think I think it was Dee's point, what are my opportunities as a first year law student? When I was in my first year of law, I was fortunate enough to get into a clerkship at a small firm in my first semester of my first year. So it's certainly possible, but I was engaged in some form of real world experience throughout my degree, especially community legal centres like yourself, Luke, and that was extremely valuable. But the way I sort of got to where I am now, so I'm currently at the Department of Transport in the commercial department. I'm admitted to practice, but I'm not a currently practicing lawyer. And the way I got there was in my last semester of my degree, I was offered an opportunity to apply for an internship at what was then PTV through a mentor program I was involved in at uni, and one thing led to another, and the internship was for a period of 3 months, and after that they offered me a full-time position, and I've been there ever since. So it's about being in the right place at the right time, putting yourself out there, showing your enthusiasm, being willing to learn, and opportunities will arise.
Well, that was a good introduction for yourself there, Mark, because that leads us into our next part, which is now getting into the tips and the setting out of doing a submission in court. So getting to the 101 kind of stuff. So we'll have some questions at the end in relation to anything that we go through now, and any questions you have in general. So what we'll start off with, and Mark and I will go through this, and if Luke's hanging around in the background.
I'm actually going to head off now, but thank you, Kurt. Thank you everyone for having me. And if there's any questions, reach out. Don't hesitate to reach out. You know my name. Not hard to find, so just reach out. All right.
Well, thank you very much for giving your time,
you,
Luke.
Thank you very much, Luke. It's a pleasure to have you here.
Thanks a lot, Kurt. We'll speak soon.
We'll speak soon. See ya. All righty. So let's start off now with some of the tips of advocacy. So the first point with Mark and I wanted to go through is the theory of advocacy, and we came up with 3 points. Now, the first is you want to win. That's the point of providing a submission to court. You want to win, well, you want to get an outcome that is favorable for your client. It's all about your client's interests. If you're not there to win for your client, well, you don't want to get your client's interests to succeed, what's the point of doing the submission? So everything you do and everything you say needs to have that at the forefront. What is going to advance my client's case in the best possible way? The second theory we had was that when you were speaking to a judge, and I think Luke touched on this, it's a legal conversation that you are having with a judge. It's a legal conversation, not a presentation. You're not reading a piece of paper. You're not reading an essay. You are speaking to the court. Now, you're not going to speak to the court how you speak to your friends or how you speak in general, but you are having a conversation in a formal sense. Do you want to add anything onto that, Mark, about the legal conversation?
No, I think you've touched on everything. Just to, I guess, as an extension of the points that you've made, just to, as part of that conversation and having your notes there and taking your notes as the proceeding goes on, just make sure you're in a position to be able to be dynamic. If you receive a question that you weren't expecting, there are opportunities to be able to take it on notice or respond accordingly. But yeah, just to try and remain agile as possible through that conversation.
And when you're having that conversation about being agile, it allows you to answer questions more easy. You know, you're there ready to answer the question. So if a judge, because when you're providing the submission, it's not an oral presentation in class where you've got 12 minutes to provide your submission, nobody interrupts you, and there's questions will feedback at the end. No, it's a conversation to the magistrate or judge. The judge is going to stop you. Guarantee they're going to stop you at some point and ask a question. Even if they're just querying something, they're going to stop you. And this applies to moots as well. And in particular for moots, 100% of the time, you're going to be asked a question during your submission. So if you're preparing for a moot, don't just be prepared to read out your piece of paper with your script on it. We'll go into how you should prepare for submissions and all that later on in the presentation. But the point is, when you engage in that legal conversation, it leaves you open and able to have that conversation with a judge and answer the questions, because it's not necessarily a one-way street. Now, our third point, which we said was in relation to the theory of advocacy, and this is something that Luke really touched on, was that know your file, know your case inside out. And I think Mark and I, who have both competed in a number of moots and also appeared in court for clients and many court appearances, know that you've got to know your file inside out. You need to be all over the facts of your case. The judge, but more so the other side, can't know something about your case that you don't know. So you really want to know your file and be all over it. So, and that applies to a moot. When you got a moot, you got to get the facts. You need to know all the paragraphs. You need to know all the facts off by heart, especially the key facts. You need to know where they are in the moot problem. And then you need to know the associated cases and know the law. Do you want to add on that, Mark, about knowing your file?
Yeah, I get what I can add to that. If there are those of you in this session that maybe are thinking about doing something other than practicing law. So in my case, I'm in the commercial space at DOT, like I said. We manage the contracts between the state and the public transport operators. So I work in the team that manages or works with Yarra Trams, I should say. And a lot of what we do and a lot of what I'm involved in are negotiations with Yarra Trams around certain elements of the contract and how they're going to deliver that contract and, best outcome for the state, best outcome for the operator and the passengers. And the points that were made about knowing your case, it seems really obvious, but you can take those, I guess, practices around getting across your case and apply them here, because when you enter into a negotiation, you've got to know your position off by heart. You've got to be confident in what you're presenting. If you make a point to the other side about, hey guys, it's our position that we're requiring you to do A, B, and C, they're going to ask you why. You've got to be prepared to answer that, and you've got to be confident in what you're saying. So I think all of these skills that we're talking about today, for those of you who are maybe thinking about doing something else once you get your law degree, or even open to doing something else once you get your law degree, these are all skills that are transferable into other areas as well.
Yes. All right. So that's the theory. So the theory of advocacy is you want to win, you want to persuade to get the outcome for you and your client. It's a legal conversation, not a presentation. And you need to know your file inside out. That's the core theories of being a good advocate in court. Now, that leads us on to the formalities. Now, before we get into the formalities, I just want to say that these formalities apply for VCAT, they apply for the county court, magistrates court, Supreme Court, Court of Appeal, High Court, Family Court, but also importantly for law students, it applies to moots. Now, the moot court, and when you do moots, even though it's the outcome of that moot is not going to have any effect and they're all made up problems with made up clients, as a law student, you need to treat the moot court as if it is a real court, because this is your one chance through your life, but also through law school, to actually present and try your advocacy skills without real consequences. Because when you leave law school, there's not much of an opportunity to do moots. So it's in moots that you really refine your advocacy skills and you refine your techniques of being a practicing lawyer. Law school only teaches you 60% of the stuff you need to know for practice. Nobody in practice is ever going to ask you to write an essay. Please write an essay with this essay topic, discuss, give me 1,500 words. I've been a lawyer now for a while. Mark's been a lawyer for a while. Mark, has anyone ever asked you to write an essay? No. Has anyone ever told you to sit down and do an exam?
No.
No. But people tell you to do court appearances and people tell you to do submissions. This is your opportunity in moots to really hone in on those skills. So treat the moot court as if it is a real court, because in a lot of moots that you will compete, you will be appearing in front of lawyers, but you also will be appearing in front of judges. So you want to treat it as real as possible. So the formalities and the court etiquette that apply into everyday courts, most of those formalities apply in the moot court. And you want to be given the impression and get into the mindset of treating the court and giving it the respect it deserves. So let's start off with the first point. Who are the people in court? Okay. Well, in most cases, you will have two barristers who are the counsel. Okay. And you have the one for the plaintiff and defendant, or prosecution and defendant. Now, in moots, but also in some more serious cases, you'll have two counsel for each side. You have senior counsel and junior counsel for the plaintiff, and senior counsel and junior counsel for the defendant and prosecution defendant. Now, the senior counsel is often the more experienced barrister. They are either a senior junior or a QC or SC. QC, SC is the same thing, just some people don't want to be associated with the Queen, so they say senior counsel as opposed to Queen's counsel. You'll find a lot of Irish barristers, not Queen's counsel as barristers. They're senior counsel because independence from the Queen. But that's a whole different kettle of fish, and we won't go into that today. So they're the people. So when you do a moot, usually there will be a senior counsel and a junior counsel. Now, the senior counsel is the person who will be opening up the case, and they will be starting off your case that you'll be putting forward. And then the junior counsel will build on that case and keep continuing, and then we'll close it off. Now, the other people in the courtroom are obviously the judge or judges or magistrates or tribunal members, and then there are other people in the court. Now, when you are addressing in the court, you are speaking to the judge, or if you have a jury, you're speaking to the jury. But for most of us at this stage, we won't be really doing a presentation or a submission to the jury. It's usually to a judge, tribunal member, or moot judges. Now, dress code is the next one. Whether it's a moot or going to court, your presentation and your dress code is important. Now, I don't think we need to go into that too much, but the expectation is for men, jacket, tie, shirt. I'm in my tracky dacks because you can't see below the waist, and you can do that in court when you're doing Zoom court, but you can't go in your trackies when you're going into real court. And then for ladies, dress code, business attire. I think everybody understands generally what the dress code and what is expected of when you go to court.
To add to that as well, blazers are never taken off.
Yes.
As well.
Never take your blazer off in court. I'll give you an example. I was in Morwell running a case on the circuit, and the air conditioner broke down in the Morwell law courts, and it was a 40-degree day in Morwell. It gets hot, and it was so hot, and we could only take off our suit jackets, and the barristers could only take off their gowns once the judge had given leave for us to do that. And about after lunch, he said, "Oh, well, look, you can take off your jackets now." So you can see how important it is to maintain it, because that's your presentation. The minute the judge walks out, he or she is going to look at you, and that is the first appearance of your client's case. Now, if you're there with your jacket off, or your tie not done properly, or your hair is a mess, or whatever, you're not sending off the great signal straight away. So presentation is key. Now, the next part, which is probably the most important, geez, it's funny that I'm sucking this up because it's court language and the stuff you need to say in court. So there are a number of phrases which you need to know when you are speaking in court, which will make the difference between you know what you're doing and giving the respect to the court that it deserves, or completely messing it up. Now, when you start off and when you introduce something to the court, you always want to start off with if it pleases the court. So when you start off with your appearance, so introducing yourself, you would say, if it pleases the court, my name is Cauchi and I appear with my learned co-counsel, Mr. Mark Andriacchio. Well, if it pleases the court, I'm now going to take you to paragraph 5 of the facts. Well, if it pleases the court, I'd like to make a humble submission. Well, we would like to make a humble submission on points 4 and 5. Okay, so that's the way you introduce yourself. Now, the next one, write this down, record it into your phone. I think I told a moot team this the other day for training. I think Bernadette is here. Put your headphones in, go to sleep and put it on repeat. We submit, we submit, we submit, we submit. That is one of the most important phrases you can use in advocacy in court. You don't say, I say, or I think, or anything along those lines, because nobody cares what you think. Nobody does.
And also, just to add to that, using a phrase like I think, we touch on again, I think the point Luke made about confidence. Starting a submission with I think, or a response with I think, it doesn't inspire a lot of confidence in what you're what you're submitting and what your position is.
Yes. So you want to be, there we go, Bernadette, we submit, Your Honor. Exactly. So when you are presenting a point, you wouldn't say, I think, Your Honor, or we're going to make this point about breach of duty. You would say, Your Honor, we submit that a breach of duty has occurred in this case. It's always we submit, we submit. You can say we say. When I'm in court, I say we say, Your Honor. That's not bad, but as a general rule, especially for moots, keep to we submit. Nobody cares what you think or what's on your mind. You're there to represent your client, and you are providing a submission on behalf of your client. So we submit is the most important phrase that you can say. So record it, put it on your wall, write it out 1,000 times, do whatever you need to do. Play a squid game with it. I don't know. Incorporate it like that, but just keep the we submit going. It is an important phrase. Now, the next one is if Your Honor pleases. If Your Honor pleases is an important term to acknowledge something that their Honor has said to you. Now, if their Honor makes a ruling that's not in your favor or has directed you to do something and you don't agree with it, you don't go up to the judge and say, oh, well, that's bullshit. Well, no, that's rubbish. All you simply say is, if Your Honor pleases, and you move on. So if you're, for example, in a moot situation, if the judges say to you, oh, look, I don't want a brief summary of the facts, just get straight to the submissions, you'd say, if Your Honor pleases, and then you'd move on. So it's the phrase that's how you would, it's an acknowledgement to the court that you've understood what the judge has said and you're going to move on. Would you add anything onto that, Mark?
I guess on the point of if you disagree with the point that the judge has made, you never say, I disagree with that, Your Honor. You would position that as something to the effect of, we note Your Honor's position, however, we take a different view of the facts, and that is this.
Yeah. Now, moving on to referring to your co-counsel, but also to the other side. The term that you would use, so let's say that you're referring to, you're the defendant. Good, we've got my learned friend. So someone has said that. That's right. So what you would say is, so let's say Mark and I are opposed to each other. Mark has just provided his submissions for the plaintiff, and I'm really appearing for the defendant. And I want to address something that Mark has gone to. I would say, my learned friend has, in his submission, touched upon a breach of duty. Well, we say there clearly has been a breach of duty, despite what my learned friend has submitted. You refer to your co-counsel as your learned friend. So your opposing counsel as your learned friend. Now, in relation to your co-counsel, so if you're a senior and you've got a junior, or a junior and you've got a senior, you say my learned co-counsel. So if they're your own team, it's learned co-counsel. If it's the opposing team, it is learned friend. So you wouldn't address your opposing team by their first name or even their second name. You would say learned friend. Now, it sounds very pompous. It sounds very out of touch with the real world, but the court system is out of touch with the real world. What other profession rocks up in wigs and gowns and funny ties called jabos and stands there and provides these submissions days on end? It is a very traditional, it is a very formal process, and that is a process that us as future lawyers, and then when you are all lawyers, it's something that you need to respect. And no matter how much disrespect you were to give it, it's not going to change that easily. So we need to use those terms to acknowledge that we give the court the respect that it deserves. Now, the next important part is when lawyers say something they don't necessarily mean to say. Now, the thing you will discover when you become a lawyer is that lawyers are never wrong and they never make a mistake. Lawyers don't make mistakes. They're not wrong. And if you don't believe me, just ask a lawyer. They never make mistakes. So when you're in court and you're providing a submission and you said something that you don't like, you never say, oh, Your Honor, sorry about that. That was a mistake. You never admit that. Because again, we go back to what Luke said. It's all about the confidence. Okay. So what do you do when you say something, but you don't want that to stick there? Well, you say, I withdraw that, Your Honor. Well, we withdraw that, Your Honor. So for example, let's say I start off reading about this page here, which is the first page is about Zoom. The Zoom United one identified app of, I withdraw that, Your Honor. And then you start on the point that you wanted to go to. Don't say, oh, that was a mistake. Oh, sorry, I want to take that. Never admit it. It shows that you don't have confidence in what you're saying. If you want something, if you want the court to disregard something, it's I withdraw that. So that's a very important part. Now, the next phrase we got here is, yes, when you are being grilled and receiving a million questions and you're not sure where to go. You never say, I don't know, I'm not sure, I don't understand. Mark, what do you do in those situations?
Well, something, and it is very nerve-wracking up there as a student when you're in one of these competitions and you are sitting in front of a real judge or a barrister. What you can do in those situations, you can ask to clarify the question, for starters, as a first point. If you're not sure, you need an extra second to think. A little trick that I would do would just be to, if it was reasonable, ask to clarify the question. Your Honor, could you please clarify that this is what you mean, sort of thing. And that'll buy you an extra couple of seconds to think about it. What was my next point I was going to say?
Don't say you made a mistake, Mark. Whatever you do. Don't say you made a mistake. You just say you withdraw it.
That's right. You withdraw it. You always withdraw it. And what I will say, so in these competitions, in our experience with them, so the judge at the time, they will not try, but they might take the opportunity to lead you down the path of questioning your argument, and more or less, if you make a point that perhaps you haven't made strongly, they might ask you something to the effect of, oh, so what was the point you made here, was that incorrect, or is that consistent with what you say or with what you just said? And you might be tempted to say, oh yeah, sorry, I was wrong about that. But you never do that, ever.
And I think the other thing, if you're getting questioned and you've taken your answer as far as you can go, what you need to say then is, Your Honor, I cannot assist the court any further on that point.
That's right.
If it pleases the court, I'll move on to my next submission.
Yeah.
So there's no point saying, don't say to the judge, I don't know. You just say that line, and 9 times out of 10, unless you get a real mean judge, which can happen, but most judges will acknowledge that's as far as you can take it, and they'll let you get on with it. And so then that's what you say in those positions where you're getting questioned, but you can't take it any further. Now, that leads on to our next point, and I'm mindful of the time. Time has escaped us really quickly, and we've got a lot to get through. But the last phrase that we'll probably, the last bit of language, is that what you do when you completely disagree with a judge. you're not always going to see eye to eye with a judge, and they may be making a points to you about your case which you don't agree with. And the correct term there to use is, we understand your Honour's position. However, we take a different view, and our position we submit is X, Y, and Z. Don't say to the judge, no, that's wrong. No, you are wrong. Or no, you've made a mistake. That won't be taken well. What you do is, but what you say is, we understand your Honour's position, but we respectfully submit an alternative view to that, or we respectfully submit a different view. However, we take a different view. So, yes, Mark.
I was going to say, and another point to make, during a competition, one of the judges might challenge your argument. It may not necessarily be that they believe it's wrong. They're just trying to assess how confident you are in making it. So don't be, if you get challenged, don't automatically assume that it's wrong, and don't concede.
Yes.
That's also another point that I've made.
Now, all right, so now that leads us into some other formalities, which are not, so that was court language, and now there's just a couple of the formalities which we thought about that need to be acknowledged. The first one is, in courts, obviously, if you haven't been to court, when you can go in person, you don't do this over Zoom. You bow when you walk in, and then you bow when you walk out when the judge is at the bench. That doesn't need to happen in moot courts. I just put that out there. But in real courts, when you go, and when we encourage everybody to go and watch a court case, to do that. Now, we'll just quickly fly through these so we can get to the next part. We talked about respect to the court. The important part we've got here is and this again goes on to the confidence that Luke said, you got to fake it till you make it. So even if you're there and you're struggling and this is not going the way you want it to go, don't show that. You just keep marching on, and you keep presenting to his or her honor as best as you can, and you present the best case you can for your client. Because if you show that weakness, that you don't even believe in your own submission, why would anybody else believe in your submission? You know, judges are not going to give out sympathy points, whether that is in a moot or in real life. They're not going to feel sorry for you. They may feel sorry for your client, but they're not going to feel sorry for the advocate. In fact, judges, especially in the real world, have this preconceived notion that a solicitor is lazy and they haven't done enough work, and the barristers are overpaid and they haven't done enough work. So they're looking at any moment they can to go, haha, I'm going to fix you up. So you want to have that confidence. You're not going to get the sympathy vote. So even if it's going badly, you've got lost, you know, you're not 100% sure. You just got to fake it to make it show that you know what you're talking about. And that leads us on to one other point, is that it's okay to ask to take a minute. If the judge has brought a point up which has really caught you off guard, you can say, Your Honor, may I take a moment? Well, Your Honor, may I take a moment to consult with my instructor? And this applies for moots. If you need to quickly speak to your instructing solicitor and you ask that, that's fine. Nobody's going to be critical of that. You're better off saying, Your Honor, may I just have a moment? It's better than going, let me think, not sure. If you just take a moment, recompose yourself, go through your notes, that's better than anything. Now the time is escaping, and I'm happy to stick around after 6. I'm not sure about Mark if he's got commitments after 6, but I do note that the next block starts at 6. So I know that people probably need to get to class. So I think we'll just get to the next most important part, which is just some tips about preparing a submission. And then
I might note, Kurt, sorry, quickly, that as we are recording it, if people do need to leave to go to the next class, that they will be able to access the recording when we upload it. And just putting in the chat right now, this is Dictum Society's YouTube channel. That is where we will upload it. It might take a bit after some editing, obviously, to upload it, but it will be going there. So if you do have to go to a class at 6, feel free to go to that and just check that channel sometime later.
Well, considering people might have to run, maybe before we continue on and get onto our points about preparing a submission, maybe we'll take some quick questions as a quick break. just to give everybody an opportunity to have a say. So look, you can type them, or you can ask them outright. Just put on your microphone and ask straight away, or you can put on your camera or do whatever you want. All right, let's have a look. We've got some in our written chat. Can you please share your internship experience, such as the best and worst parts? Alrighty. My internship, well, I did a number of internships through the uni and through my own exploring, one of which was working with a barrister. And that was purely just going, knocking on the door and going, can I please have work experience? And making my luck from that. The worst part about it is you don't get paid, but you can't buy the kind of experience that you learn in internships such as West Justice, Magistrates Court, Legal Aid Program, and something that you can do which you don't need permission for, you don't have to ask anyone from, and Mark would agree with this wholeheartedly because we spoke about it, is go to court.
Yeah.
Attend
absolutely.
court. Listen to how great preparation of a case and great advocacy comes to a head.
Yeah.
I used to spend a lot of time at law school between classes, or after classes, before classes, just sitting in the Supreme Court and the county court. Just go in and listen. And now I know with COVID, you can't do that. But if you go to the county court website, I've seen there is a special email address you can email as a law student, and that will send you Zoom links to sit in. And I've been in court cases for serious injury applications where law students have sat in to observe. So COVID is not an excuse not to go to court. In fact, it's even easier to go to court now.
Yeah.
So that's one of our big points, is go to court, read, listen.
And to add to that, on the point of going to court, obviously it under the current sort of COVID environment, it doesn't really apply now. But the point that Kurt made earlier about treat the mooting competitions as though it is real life. When we are able to go to court, dress up, put a blazer on, make sure you look smart, because also you don't know who you're going to bump into there. I remember one particular case, I sat in on a case at the Supreme Court. The barrister made his submission, and at the end, a group of us, I think I was in my first or second year, we cornered him and he gave us a rundown of the case. What did you think about this? What did you think about that? Gave us an opportunity to ask him questions. He asked us questions. And at the end of it, he gave us 15 minutes of his time for no reason. And we got business cards and all that sort of stuff. So you don't know what sort of opportunity is going to come your way. You don't know who you're going to bump into and what's going to come out of it. So, yeah.
Well, I've got the exact same experience that it wouldn't happen in the Supreme Court because you're so far up in the public gallery, but in the county court, because you're so close to when you're there in person, because you're at the same level as the barristers, after that they'll look at you and they'll know straight away that you're a law student, because not everyday people don't go watch court cases, and they'll engage with you and they will ask questions and they'll say, oh, what are you here for? And that conversation may lead to you doing a week's work experience with a barrister. You just don't know what kind of luck you are going to run into.
Yeah.
So if you don't put yourself in that position, you just don't know. If you're not there, the opportunity's just not going to be available. And I've just seen that the president actually is just put up the communications. I would just Google that, and that is the address. So the email address to go in and watch court hearings. Now,
yeah, I've just also put the link to the county
we've got
court
multiple
website
links.
page for it.
All right. So I noticed that Grant's got his hand raised. So we'll go to Grant if you've got a question. I tell you that's where your hand is, right? Yes.
Yeah, thanks, Kurt. Look, it's in regard to you say never say we've made a mistake. How do you respond when you catch a junior co-counsel say something that you think, oh God, don't say that? How do you? I mean, we can't retract it, but how do you address that issue?
If you hear your co-counsel say something wrong.
Yes.
Well, there's two things you can do. One, you just sit down and bite your lip and just bite your tongue and go, well, that one's just going to have to fly. Or if it's a really catastrophic thing, write a note, put it in front of your co-counsel, let them read it, and then your co-counsel can read that and go, oh, Your Honour, in relation to the submission I made to duty of care. I just want to clarify one point to the court. We submit in relation to that point, this, and this. So that's a way you can get around it, is simply quickly write a note and go, you said this case wrong, or said this, and fix it. But sometimes you just have to let it fly, because there's no way. You can't stand up and correct your co-counsel. That's the worst thing you can do, because not only does it undermine your co-counsel, it shows that you two are not on the same page. So you might just have to let it fly. But if you can quickly write a note, give it to them, and then they can correct themselves without saying that was wrong, just say, oh, you're on in relation to that point, we want to clarify something. We want to clarify that submission. That's fine, and that's acceptable.
And also to that point of passing notes, you really want to minimize, well, I'd say try not to outright talk as much as possible while giving a submission. So, pass notes instead of whispering across the table, sort of thing. So have a little pad of sticky notes with you and be prepared to scribble.
Just quickly to hijack the question time before people leave to any classes that they have, we would like to advertise that we do have a witness examination competition coming up for students who are interested. You can view the problem rules and register for it on that link there. And we also have our annual general meeting and elections for the 2022 Committee of Dictum coming up. If you're thinking of joining the committee, please submit your nominations there. And if you're not thinking of joining the committee, you're still welcome to join in on the meeting for the vote. We are, after all, student run and student voted in. But that's all I really have to add there. I'll let you guys get back to the questions.
And the next question is, have you ever dealt with a legal matter that was emotionally challenging? Yes, that's from the competitions director. I do personal injury law. That's my predominant practice, and I do work cover. So my cases involve everyday people and workers getting injured at work, and the consequences that can lead to can be very significant. I'm currently going through a lot of cases that involve stonemasons sustaining silicosis. And I've got one particular client who's been given, only a few years to live. And so that is very emotionally draining and challenging. But yes, I've got so many cases. I've just finished off the Maria James inquest, which is the lady who got murdered at the bookshop in 1980 in Thornbury. And there was a whole coronial inquest into that as to who is her murderer. There are a number of suspects, and I must say, after 3.5 weeks in court and 5,000, 6,000 so pages of material, we're no closer to really knowing who actually committed the murder. And that was emotionally challenging because of the two sons who've grown up without their mother that just want answers, and you work as hard as you can and do huge hours, but at the end of the day, you're just not going to be able to provide them that answer because there's just so much missing evidence from 1980. And when we get that time machine, we'll go back there and collect the missing data. But at the present time, you just can't do that. And probably another emotionally challenging case for me was I worked during law school as an assistant for that barrister. I worked on the Royal Commission into child abuse, and reading some of the material in that was very confronting and very difficult. So in those cases, the advice is, at the end of the day, they're cases and that's work. And you can use that emotion to spur you on and to make you work harder. But once you turn off your computer for the day and, you're finished for the evening, you just got to put that behind you and focus on other things. But yeah, being a lawyer is emotionally challenging depending on the practice area. And in my area, people law, where my clients are actual people, not banks or the Department of Public Transport or Yarra Trams as is Mark, there are real people and their lives get affected by what your work does. So the law can be emotionally challenging, but you just got to remember that you're doing your job. You got to do it as best as you can for your client, and you move on. And just give them the best service you can. Now, next question was from Joey. Court, great, thank you. Thank you. As when question lecturers I received, you can't, even when mentioned Zoom attendance. Joey, can you clarify that? Joey, we can't hear you. Can you? I can't hear you very well.
Earlier. Sorry, I'll move right in. Can you hear me now?
A little bit better.
Lost.
Okay.
Let me turn it up.
It's,
Oh,
it's been sorted. It's just that the lecturers that I've been asking in relation to court visits via Zoom, just got to blade straight out. You can't.
Yep. Well,
It's just been rectified. We've been given links, but I'm a bit curious why they wouldn't know that. But that's another story, isn't it?
that is another story, and I can't comment on what the lecturers have said,
No,
but
that's why I'm not going down that track.
yes, no, you can, and
But
I would
now
encourage you to
links, I
reach
really
out to.
appreciate that, because that's all I've wanted to do is during my course jump into a Zoom session to get some experience.
Yes, and well, you got that link, so email that through, and
So thanks for that.
no worries. So yes, well, I'm glad that's been clarified. Oh, my emails are popping up. All right. This is from Jasmine. What is your greatest advocacy achievement? More specifically, most memorable advocacy moment where you've achieved what was best for your client? Well, I've got two. One of the best advocacy moments was this moment here, where Mark and I, you can't see the photo, did our moots together when we were at law school. And that was a great moment because we had a lot of fun doing the moot. We went up against some great teams. We appeared in front of some real judges and legal practitioners. We developed a lot of skills. And we learned teamwork, what to do and not what to do in a team. But it was great fun. It was on, and we're still, obviously friends. And I don't know how we managed to not kill each other during the moot, but
well, we're stuck in lockdown now.
So no, but look, that's one of my great achievements was doing. Yes, was that moot, because learned so much from it, but also just had a great time at the same time.
Yeah, and we still laugh about it today. I mean, that was 4 years ago.
Yeah, so it was a good moot, that one. What was your greatest advocacy achievement, Mark?
Well, for me, so I've been at the Department of Transport since I left uni, but like I mentioned, while I was a student, I did a number of clerkships and internships. If I had to pick my greatest advocacy achievement, I was doing an internship at West Justice in Sunshine. I had a particular client, and the beauty of these youth justice internships is, as a student, you're working under the supervision of a lawyer, but the clients are your clients, the cases are your cases, you run them. So as a student, this client was my client. He had a number of driving infringements that I think he'd lost his license a number of times. He was looking at some jail time. He had gone through some very, very, very difficult personal circumstances. He was a very difficult client to deal with because of those personal circumstances and some mental health issues. He was not in a good place. We ran his case. We appeared in court, and that Friday before his court case, he was emotionally at rock bottom. It was quite sad. We got an unexpectedly good result for him. He avoided jail, and he came back on Monday, clean clothes, haircut. I didn't recognize him. He wanted to shake my hand, and it was really nice. Through the work that we'd done for him, we'd help him. We were able to help him sort of take that next step on his own journey and in avoiding that jail time, hopefully turn his life around a little bit. So yeah, that was something that stuck with me for a long time.
Yeah, and then just one of my other advocacy, I think, cross-examining George Pell. I didn't personally do that, but I was involved with my boss cross-examining George Pell. That was a big advocacy moment. But personally, for me, being in court, was putting forward a submission for a client who'd been injured, and managed to get something sorted out in the interim until we got to the proper court hearing, so I could get counsel, and we got a little win there. So that was something quite good. So thanks for that question. I think that was Jasmine. Okay, next. What would be your best advice to compartmentalize when these emotionally challenging times occur? I think I've gone through that. Is, you know, when you're at work, you focus on work, you channel that energy as motivation, and then you know, when you finish work, you try to figure. I'm giving this advice. I'm the worst when it comes to switching off. I don't stop thinking about work all the time. I'll wake up at 2 o'clock in the morning with an idea, and I'll get up and write it down on a piece of paper and go back to bed. So, but the advice that I've been given and that people should do is, you know, you try to switch off as best as you can, and just fill that in with hobbies. Surround yourself by good people. That's the best you can do. Now, the next question is, how do you tread if you suspect your client is lying? Well, that's a good question. What do you reckon, Mark?
Well, there are a number of things you can do. As a first port of call, I would speak with the client and just, you know, really emphasize the importance of, as that client's lawyer, giving me the full story, giving me the full picture, and sort of what implications that would have for them. And hopefully that might change their approach. But if not, and I'm quite rusty on the rules around this, but under certain circumstances as a lawyer, you are able to, and Kurt, back me up here, I believe, recuse yourself from representing a client in the case that you have reason to believe that they are being untruthful, because your overarching number one obligation is to the court and to be truthful to the court.
Yeah, and I agree. Look,
yeah,
you don't call your client out for lying very lightly. So this is the approach that I take, because I come from a background in my field of personal injury law where there's a stigma that all workers on workers' comp are liars and thieves and are just scamming the system to get compensation. I would say probably 95% of my clients and the people I meet every day are genuinely injured workers who have got real injuries, and that has a real effect on them and prevents them from doing their pre-injury duties. I think it'd be even less than 5%, where you go, well, that doesn't seem right. The conception and the notion that people like that are lying is completely wrong. No, but once you go through the work cover scheme or the TAC scheme, but particularly work cover, you will do anything you can to get out of it, because it is a horrendous, mean-spirited, soul-destroying, crushing system whereby you just, by the end of it, you just want to get out. So I do it every day, and it's just an absolute nightmare dealing with insurers. Things like the phones just hang up on you. You can't speak to people. No one responds to your emails. So I always, when I assess whether somebody's lying to me, if I don't have solid evidence, I let it run, because when you get somebody in the witness box, the truth always comes out. And I'm a firm believer that when you go to court, the truth generally always comes out. You cannot lie about an injury or about the circumstances of it. You'll get pulled apart, because you will face some of the greatest legal minds and barristers that Victoria has to offer, and they will unpick you, and they will do a great job at it. And in some degrees, it's very entertaining. But with Mark said, if you know your client is outright lying, so for example, if I go through the medical material, or I see video evidence, or I see statements, or I come across a piece of evidence that clearly indicates that somebody is lying. When you do this, when you do civil procedure, you have to do your overarching obligations to the court, or when you file your writ or originating motion. Okay. And when you sign that, you need to acknowledge that the claim has basis. So as a lawyer, I can't sign that if I know generally and I've got significant evidence that my client is lying. And it's at that point that you advise your client that you cannot act any further for them, because of this evidence, and that you're going to pull your representation, and then you provide them advice they should not pursue their claim any further because it's a detriment to them. So, and I always give the warnings to my clients when I get them to sign the overarching obligations. You've got to tell the truth. And when they go see doctors, where they go see anybody, all you need to do is say the truth. You say it as it is. You don't over exaggerate. You don't under exaggerate. You tell it as it is. You tell your life story as it is. Nobody's going to have a problem with you. And the truth will always come out. So, yeah, that's what I do when you get an inkling. So you can't just outright call it unless there's sufficient evidence. If you suspect but you haven't got the basis to prove it, you let it run its course. But if there is clear evidence that there's lying going on, you withdraw that, because as Mark said, you've got the duty to the court, but then that also conflicts with your confidentiality. And I'm not going to get into confidentiality with criminal clients and what comes over that, because of the competing duties, because that's a whole seminar which we can spend 2 hours debating on. Now, the next question: what's your best advice for a law student who has just completed their degree and is beginning or attempting to begin their career? So the best advice there is get yourself into a job that it may not necessarily be a lawyer or grad job, but get yourself into a role which can lead to being employed as a lawyer or give you legal experience. For example, at our firm, Slater and Gorn, we have legal assistants, and that gives you the exposure. You're not doing lawyer work. You're not a lawyer, but you're doing legal work. So get that degree. If you can't get a grad role or get a first-year lawyer role, get a job or some sort of role that exposes you to the legal world and the legal formalities. I think if you can't get yourself into that role, keep calling up the community legal services. Just get any experience you can get, because at the end of the day, there are thousands of law graduates that graduate from university, and there is only a handful of jobs. So good grades alone are not going to be enough. And that's where, when you do moots, when you do work experience, free work experience, it can really boost your ability to getting that grad role or getting a job when you leave uni. At the end of the day, HR are going to get 500 to 1,000 resumes. Now they're going to go through it. Everyone, if you're a lawyer, we're all smart, we're all clever. That's why we're all doing law, okay? And a lot of people are going to get great marks, okay? Great marks are not enough. So they'll look at it. All right, Mark's done 2 moots in his time. Kurt's never done a moot. All right, let's look more into Mark's. Oh, Mark's done work experience. Kurt hasn't done work experience. Well, let's throw Kurt's out, okay? That's exactly what's going on. It's about the experience. And also the other part is who you know in the law. And that's why building, and I hate the word networking, but you've got to network, you've got to have connections, you've got to get your name out there. Take every opportunity that is at your door or in front of you. Just grab it and run for it. I got my grad role because of the opportunities that presented me and for putting my name out there and through my connections. So I don't come from a legal family. I'm the first person in my family actually to go to university. I disappointed my father and my grandfather because I should have been a carpenter and been the 5th generation carpenter, but I decided not to do that. So, it doesn't, because of your background and your upbringing, that shouldn't be a reason for you not to get into law. You just got to work hard, not only at law school, but in developing your broader community and connections. And I think Mark would agree with most of what I've just rambled on about.
Yeah, no, absolutely. All of those things. I don't have anything to add. I think you summed it up pretty well, but yeah, agreed.
Now, next one is to Mark from Bernadette. So finally, you're going to say something. All right. I'll read it to you. I'll read it on behalf of Bernadette. Would you, by chance, practice as a solicitor or a barrister eventually?
It's an interesting question. So when I was studying law, I never had intentions of doing anything other than practicing law. And as I mentioned, I did some clerkships and some internships. The last semester of my degree, I wound up doing the internship at PTV, which is now DOT. And I really enjoyed it, and I stayed on ever since. And I think because I went into it with no expectations, that allowed me to really, I guess, make the most of the opportunity when I was there and just experience it for what it was to see if I enjoyed it or if I didn't. To your question specifically, I would like to practice one day. What I've found about working in the commercial space as opposed to the legal space is the commercial space is very interesting, it's very strategic, and you've got the work we do, it's not legal work because it can't be legal work because we've got the legal department to do the legal work, but it's from a commercial point of view, from a contractual point of view, it's pretty close. It's, you know, giving advice on the contract, contractual interpretation, drafting documents that are not by necessity legal, you know, legally binding documents, but I mean, they look like a contract, you draft them like a contract. So, you know, being a lawyer really helps. But what you get in the commercial space is that strategic element of, you know, what's possible and not possible in accordance with the contract, what's legal and not legal, but also what is strategically the best decision to make on behalf of the state, on behalf of the passengers, and sort of thinking about the negotiations between us and the operators, how what's, you know, the best way to position ourselves in terms of our arguments, what we want, how we can leverage that, and all those sorts of things. So it does add, there is, I guess, an extra dimension to what we do, which is really interesting. So to sum up your question, I would like to practice one day, but I do enjoy what I do because of the strategic element to it. Yeah, hopefully that makes sense.
And a lot of your role is very legal, isn't it?
Yeah. So, for example, I've just been drafting a document that's a mechanism under the contract that we're looking to formalize with the operator pretty soon. It's, like I said, it's by definition, it's not a contract, but I've drafted it as though it was. And you don't have to be a lawyer to do my role, but the people that in the commercial space at DOT or in any commercial space that are lawyers, we are pretty highly sought after a lot of the time because of our contract drafting skills and even legal drafting skills. The legal letters that we draft are not legal letters, but the same principles apply. So, you know, they're all very transferable skills. Like I said before, if you're thinking about using your law degree for something other than practicing, there are a lot of things you can do.
All right.
Yeah.
We better get moving on. D, you've provided 3 questions. I'm going to pick one. How many people you graduated with still do not have jobs? I would say if the vast majority of people that we graduated with, because Mark and I graduated similar times, most of them have got roles.
I saw that question. I can't think of anyone that I know that hasn't got a job at this stage.
Did everybody walk out of uni and get a graduate role which paid for their clerkship or their traineeship? No, not everybody got grad roles, but people persisted and took avenues and put themselves in a position which led to getting a job in the legal industry, whether as a lawyer or in a legal capacity. So persistence and determination are just as powerful as your degree. So just keep chipping away and trying to get the best role or position that you can get. Bernadette has asked to me, okay, would you one day be an academic and stop practicing? Would you by chance work part-time as a moot trainer? Thank you. I probably would not stop practicing because I really enjoy practicing law and I really enjoy being a solicitor and lawyer. I love having clients. I love being in court and I love working on my files. So I probably wouldn't stop that, but I would be open to part-time university lecturing because I think it's important to bring real life experience into the classroom or into the seminar room now. We don't do lectures at VU, so to speak, in the big lecture theatres because of the block model. But yes, and also to be moot training, yes, I'd help out with moot training and coaching and assisting as I can, as this is here. Now, Michael, you've raised your hand, so I say you want to say something.
Very quick question of little consequence. Luke was mentioning parking tickets. I got a parking ticket when I've chosen to take it to court.
Yep.
But I want to plead guilty, but with mitigating factors. Well, how would you open with your first line to the court? You know,
All right.
pleading guilty or whatever.
Okay. I suspect, look, with parking tickets, they're strict liability offences, so it's hard to get out of. But if you were, you know, the first thing is you introduce who you are and you do your appearance and you say, you know, Your Honour, my name is Michael and I am representing myself in this proceeding. So you've introduced yourself.
Yep.
And then you would say, Your Honour, whilst I intend to plead guilty to this offence, there are a number of mitigating factors which I would like to raise at the court.
Yep. Well, that's pretty much what I thought, but yeah.
But I don't know how great your chances are going to be.
Sure.
Of getting off the parking ticket.
No.
All
right. I've got plenty of mitigating factors.
Okay. Well,
I'll just take, one question from Dee that's actually directed to me, and then we can move on with your rest of the presentation. Thank you very much. So Dee did ask, are opportunities to mooting available to first year students? There are. Generally, a lot of the competitions that aren't moot, such as the negotiations or witness examination, they're easier for first year students to go into than it is to, say, try at an external senior or criminal. But there's also at the start of every year generally a junior moot. That's the best place for first year students to wet their teeth on moots.
Yep.
And that's all I have to say.
Okay. Well, okay. Just quickly, difference between a barrister and a solicitor. Very quickly there. A solicitor does all the preparation for court work. The solicitor is the face for the, you know, they work for a law firm like me. I'm a solicitor. I work for Slater and Gordon. Clients come to me with their case and I work on it and I prepare it. And then when I need court work or expert advice or anything along those lines, I brief a barrister. And the barrister is the person who will either give me expert advice, draft me court documents, or provide the submissions to court if we have a hearing. So essentially, the barrister is the voice and the solicitor is the slave. So we just go about doing all the background work, preparing a brief for the barrister to present in court. Of course, not everything gets litigated. So if things don't get litigated, we don't necessarily need barristers, but sometimes there are legal documents that we need barristers to draft, such as affidavits, a serious injury application, particulars, discovery notices, answers to interrogatories or interrogatories to the defendant. So that's the main difference. All right, so I think some people are leaving, so thank you for joining us, and I know we've gone extremely over time. We better get back onto our presentation, and I think we might move we've gone a bit back to front here, but there was a lot of content to squeeze into an hour, but I'm glad there's still 32 people, minus Mark and I, so there's 30 people straggling along with us. All right, so we've gone through the formality. Now let's go to presenting your submissions in court. All right, first thing is appearances, not necessarily how you physically look. We've discussed that, but making appearances. When you get to court, whether that's the moot or real court, a judge is going to say, I'm going to take appearances, or I will now take appearances. Now, that doesn't mean you stand up and take a photo or anything like that. What it means is you're going to introduce yourself. So the way you do an appearance is essentially very simple, straightforward, and you'll memorize this once you do enough moots. But what you say is, if it pleases the court, my name is Cauchi, and I appear alongside my co-counsel, Mr. Mark Andriacchio. We appear on behalf of the plaintiff for this application or these proceedings. Now, then in court, you would normally sit down, and that would conclude your appearances. It's an opportunity for the judge to know who was before them. But in a moot situation, the only difference is you would say, after you do that, you would then say, if it pleases the court, Your Honour, I will be speaking for 15 minutes and Mr. Andriacchio will be speaking for 10 minutes and we reserve 5 minutes for rebuttal. You would never reserve 5 minutes for rebuttal, but we reserve 1 minute for rebuttal or 2 minutes to rebuttal. And that's it, then it'd be done. So that's your appearance. It's no argument. It's not introducing your points. It's purely just introducing who you are. Once you do that, you sit down, and then the other team stands up, the respondent, and say, if it pleases the court, Your Honour, my name is Cauchi. I appear alongside Mr. Andriacchio for the respondent in these proceedings. And then you would sit down. But in a moot, you would stay up and say, I will be speaking for 10 minutes and Mark will be speaking for 9 minutes, and we reserve 1 minute for Sir rebuttal. So in a moot, you have rebuttal for the applicant. So that's a chance for you to rebut anything the respondent said. And then Sir rebuttal is your chance to rebut against the applicant's rebuttal. So that's an appearance. Okay, introductions. Now, your introduction is your opening of your case. It's probably one of the most important parts of your case. Why? Because it's the first thing the judge is going to hear about your case. You want your introduction to be snappy. You want to signpost. It sets up your case. What is signposting? Well, signposting is what you're going to talk about. So you would say, Your Honours, you'd start off and say, Your Honours, this is a case about a injured worker who sustained injuries as a consequence of the negligence of the defendant. And then you would say, Your Honour, in my submissions, I'm going to cover X, Y, D. My co-counsel Mark is going to cover points X, Y, and C, or A, B, C. So in your introduction, you want it to really open up your case, set the tone of how your submissions are going to go, but signpost. And that's a really important part about signposting. And I think Mark made this point, and we'll get to it later, but essentially the signposts act like subheadings.
Yeah, verbal subheadings.
Verbal subheadings. Because at the end of the day, you're going to be providing a submission, whether it's in court for, I don't know, an hour, or in a moot court for 10 minutes. There's a lot of words being said. So you want to make it as easy as for the judge to follow what you're saying. So in your introduction, if you can tell the judge what you're going to talk about, and then what your co-counsel is going to talk about, at least they know where everything is going and what's going to be said. In the introduction, it's also an opportunity for you to ask their honours, especially in a moot, if they would like a summary of the facts. Don't always assume that the judges have read the facts, because a lot of the moots that I judge, because I'm just so busy at work, I don't always get a chance to read the facts properly. So I do benefit from a quick summary. And it's a good test as a judge to see if the team in front of me has actually read the brief properly, and whether they're getting names, dates, all the key little bits and pieces correct. Mark, you got anything to add for intro?
No, I think you've covered it off pretty well there.
Yep. All right. Well, now we'll move into the crux of providing a submission and all your arguments. Okay. Make sure it is clear what you are talking about. Make sure it is clear when you start on a new submission or on a new point. I've just seen a question pop up. Do you mention the firm in your appearance? No, you do not mention the firm in your appearance. The firm gets no mention at all. So no, don't mention the firm. Thanks for that, Michael. But so now back to the arguments and submissions. Like what Mark was saying, verbal subheadings are the best thing you can do. Your Honours, my first submission is going to be in relation to establishing a duty of care. Then I will be making these points in relation to a duty of care. Your Honour, I now move to my next submission, where we will be submitting that the duty of care has been breached. In my submission, we will be submitting . So the judge can literally sit there with their pen and go, all right, duty of care, these are the points he makes. Breach of duty, this is the point that she makes. It just makes it simple. Imagine you're writing an essay and you don't have subheadings in it, and it's 2,000 words of black and white letters. It's going to be hard to follow. The simplicity is key. So if you can keep it simple, you're going a long way. What else would you say in relation to making submissions, Mark?
What else was I saying? Excuse me, in relation to making submissions.
Well, I think, yep.
Go on. No, just to say that. No, I think you're covering it off there pretty well.
Okay.
Yeah.
So simplicity is key, keeping it simple. And the best lawyers are the lawyers who can take very complex legal concepts and make them very simple. Anybody can read out of Cheshire and 5 Foot or the equity and trust textbook and regurgitate the information. But the best lawyers take the most complex concepts, such as the equitable maxims, and simplifies them so much so that the layman can understand it. The art of great advocacy is presenting a very complicated argument in a very simple way that the judge can follow. Remember, a judge is going to spend a lot of time listening and trying not to doze off. So if you can get that information and make it as simple and legally simple as possible, you're already having a very convincing argument. So try to take those complex legal maxims or the law and try to make it as simple and as straightforward as you can.
Try to, I guess, if you're going to liken it to anything, in as much as possible, verbal dot points when you're making your explanations. Short, punchy sentences. I mean, it's difficult when you're in the process of the competition because you're nervous and you're trying to make the best submission possible. Try not to ramble on. Try to keep it short. And also the way you kind of signpost your way through your argument will help you keep track of it as well.
And what Mark's saying there leads me on to the next point in relation to preparing your submissions, is that it is not acceptable to write a speech. Okay, yeah. You cannot write a speech, whether it is a moot or whether it is a court appearance. Those advocates who go to court and read off a piece of paper, they're not going to do well, and the judge is not going to look at them favorably. The greatest advocates are the ones who speak directly to the judge, and it goes back to the theory of a legal conversation. A legal conversation is not you reading your transcript or your running sheet to the judge. The legal conversation is engaging with them. So the way I go about preparing a submission is I have my actual headings, which are the verbal subheadings, and then I have dot points. And I have key points that I want to get across. So for example, if I've got establishing a duty of care, I'd have established duty of care. And then I'd have the cases I want to refer to, let's say Donoghue and Stevenson, okay? And then I have the key facts I want to go back to. I don't waste space or time with in-between words as a script, because if you have the script, your brain is naturally going to go and read it. And you don't want to be memorizing it. You want to be talking to those points. So then when I'm at the bar table and I've got the, I put my paper there and I've got my dot points, I just go through and mentally tick them off as I go through. So when you prepare your submissions, don't prepare a transcript, don't prepare an essay. The way I would recommend it, to ensure that one, you're having that conversation, and two, ensuring that you're not reading, is you just have simple dot points that prompt you to provide important critical information. Okay.
And as part of that submission as well, you've got to be mindful of the time, because you are being timed and you will be held to that time. A kind judge might give you an extra minute or two if you're doing really, really well. Others will cut you off mid-sentence because your time's up. So when you're writing your your subheadings and your dot points down, order your arguments under each subheading as most important to get out to least important to get out if you have time, and be prepared to scrap the final point you're going to make because you've got to move on. Have a watch with you if you've got one. Try not to have a phone on your desk, and try to be mindful of the time, because it's not a nice feeling when you're about to come up to your home run point and all of a sudden counsel, you're out of time.
And also the other point with Mark there is that just doesn't apply to moots. Judges, and a part of the real push for courts to become more efficient and deliver justice in a more efficient way, is they will cut you short if you're giving a submission and they feel like you're rambling. They will say, "Oh, Mr. Cauchi, is that really relevant? Well, Mr. Cauchi, how much longer are you going to be? Well, Mr. Cauchi, I note the time. Is this of any relevance?" So they won't necessarily just cut you off, but you want to be efficient. and you want to, every word you say to the judge, you want to be of importance. So it's the moot is a great way to train to getting the most out of that time, maximizing your argument in a limited time. Because a judge is going to appreciate if you can deliver a powerful submission in a short amount of time, rather than rambling on for 4 hours, wasting the court's time to really deliver points that could have been said in maybe 50 minutes. So that's where simplicity is key, and not reading. Now, with the not reading and having dot points, it allows you to answer questions from a judge more easily, because you're not following a script. So if the judge interjects, you answer the question, and then a good skill which Mark brought into is that you try to, when you answer a judge's question, you also try to slide in your own submission into that. So don't just answer the question whilst also proving your case at the same time. Don't go on to something completely irrelevant, but if the question permits you to slide in your submission there, you should do it.
Yeah.
Because you're not only answering the question, you're also making a submission, which kills two birds with one stone. Now, and then of course, in your submissions, you want to be referring to the facts regularly. Everyone has this perception that the law is more important than the facts. Wrong, 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 wrong. The facts are more important than the law. Why? Because the law is not always in dispute, but the facts of a case are in dispute. Okay. And in moots, then the facts, the agreed facts are not in dispute, but you want to draw upon the facts because that's your evidence. And then you apply the legal principles to that evidence. So the IRAF method of writing an essay is essentially how you go about providing your submissions. You're applying the facts of your case to the applicable law that you're submitting to the court. So in summary, for arguments and putting together an argument submission, verbal subheadings are critical. Signposting of verbal subheadings. Keeping it simple is important. You want to make your submission as simple and as clear as possible. Clear language, slow. You want to give your submission in a slow manner. You don't want to be talking like this, but a nice, calm, collected way. Mark, what did you say about when you feel like you're talking slow?
The general rule is, so if as you're talking, you think you're talking a little bit too slowly, you're probably spot on. Because when you're there answering a question, especially if you're not 100% confident in the answer, you'll find yourself, it feels like time stops. You just want it to end, but you've got to get an answer out. So 2 seconds starts to feel like 5 seconds, starts to feel like 10 seconds. So if you think you're speaking a little bit too slowly because you're in that state of nervousness and your brain's ticking over so quickly, that's where you're probably spot on. If you think you're speaking at a normal pace, you're probably speaking a little bit too quickly, and you want to dial it back a little bit, take a deep breath, and slow it down a notch. Yeah.
Because what I see when people read, they rush and they run through and there's no eye contact. You want to be making eye contact with the judge. If you're at home in Zoom, you want to be looking directly at your camera. You want to be talking in a clear, strong, affirming your point, and making that submission with confidence.
Yeah.
So to summarize, make it clear, verbal subheadings, simplicity is key. Make the complex legal problems or concepts as simple as you can make them. Refer to the case law, refer to the legislation, take their honors to the relevant section in the law. Don't necessarily read it all out, but read out the important part, which really goes to your submission. Take them to the case, read out the important paragraph, or give them the opportunity to read it. So know the law and simplify it for the judge. Make sure your submissions are in dot points, not a script. That allows you the flexibility to answer questions so you can answer them as best you can, then get back onto it. And then refer to the facts, apply the facts. The facts are your client's instructions or in a moot, the facts you've been presented with. and you've got to win on those facts to get the outcome you need. So that's what we say in relation to argument submissions, unless Mark wants to add something in there.
Just to, I guess, in that context, reiterate a point I've already made. So when you're making a submission, don't say, and if the judge challenges you on a point, so for example, I don't know, can't think of an example right now. So something to the effect of, so is this what you're saying about this point? So because of this, that's what your argument is based on. Is that correct? That's not necessarily them saying you're wrong. They might think that, oh, Kurt's doing really well making the submission on this point. I want to see how well he knows this argument. I want to see how we can flesh it out. So he'll try to get a little bit more out of him. So don't be put off by that, and don't, I guess the temptation is to clam up and get nervous and maybe apologize for the point that you made. Stick to your guns, see your point through, and you could be surprised by the result of doing that. And I think another point I'll make just quickly, I think we forgot when we were discussing the terminology, Kurt, one of the particular terms. So when you're referring to a case, the first time you refer to the case, you refer to it in full. So, you know, you picked Donahue and Stevenson, and it's been a while since I've had to refer to the case to a case. So I might leave that to you, Kurt. And then so you'd refer to the full case, and then you would say, Your Honour, may I dispense with full citation from this point? And so from that point, they'll say yes. The next time you refer to a case, then you'll just refer to Donahue and Stevenson without having to make the full citation.
That's a weird moot rule that doesn't apply in real courts. You never would dispense with full citations, but essentially, if you're reading out a case for the first time, you would say Skelton and Collins, 1966, 115 CLR 94. If it pleases the court, well, if Your Honour pleases, may I dispense with full citations? And they will say yes. And then all you need to do is read out the case name when you refer to another case. But the first case, you got to read out the full citation. Now, in relation to that, we're not in America. We don't say Skilton v. Collins. It is Skilton and Collins. You never say v, because we adopt, the English system. So when you see the v, it's always and. So Donahue and Stevenson, not Donahue v. Stevenson. March and Stramere, not March v. Stramere. Marbo and the Queen, not Marbo v. the Queen. The V you always say, and it's not versus, it's always the V stands for and. So it's party, plaintiff, and defendant. So that's an important distinction. You always say that in court, but if you say that in the moot, it really shows what you're talking about. In relation to, we can move on to doing a conclusion now. So this is really for junior counsel, but you'd also do it as senior counsel because you'd want to quickly summarize what you've just presented on. Why is this important? Because the introduction, you've got your judge's attention. A judge's attention will kind of falter in the middle. They'll come in and out of what you're saying. That's just human nature. But the conclusion is where they'll they'll go, oh, good, we're finishing up. Let's hear what he or she has to say. So it's a good chance to re-put your case in summary form. So you want to make it powerful. You want to summarize. You do not introduce new information or new cases or new law in your conclusion. It's purely an opportunity to summarize what you said in about a minute, maybe 40 seconds. Your Honour, we've submitted in our humble submissions that a duty of care existed to this client because of the relationship that existed between them. And we say that when you consider all the facts, in particular, the fact that the snail was in the bottle and nobody checked the bottle, that negligence has occurred, and this has led to a detrimental loss to our client. And we submit that our client should be awarded damages for that reason. So you don't introduce the law, but you restate the facts you've already gone through, you make it punchy, and you tell them what you want and you get out. That's essentially a conclusion. Wouldn't you agree, Mark? Punchy, straightforward.
Punchy, straightforward, and you may be in a position where you forgot to reference a particular case during your submission. There may be a temptation to try and slot it in there. Don't.
No, it's done. It's time to move
done.
on. Now, this next point, rebuttal, is in relation to really moots. A rebuttal, the way I always talk about rebuttal to clients, not to clients, to when I'm training a team or judging, is I always say, listen to Ronan Keating's song. You say it best when you say nothing at all. Okay? Because sometimes rebuttal, the best thing you can do is say nothing. Unless you got an absolute brilliant point which you can make to respond to the other team, don't say anything. Because if you just do the drop mic and go, we waive our right to rebuttal, Your Honour, it kind of shows that you have confidence in your submission, that what you said in your 20 minutes or 10 minutes or hour, whatever it was enough to carry you over the line. I've seen people get up and do rebuttal for the sake of doing rebuttal, and it just does not help. It does not help. In fact, it makes it worse.
Yeah.
And one thing is, if you are going to do rebuttal, no new information, no new facts, punchy, 30 seconds, get to the point. If there's something the other side that has said is completely wrong in law, you say, oh, Your Honours, my learned friends refer to Section 58 of the Wrongs Act, which is in relation to duty of care. They mentioned the salient features or the wrong shire. Your Honour, we respectfully disagree with that submission. And we say, if you in fact look at this case, which we referred to earlier in our submissions, that completely overruns what they said or something along those lines. So it's just a single killer point. Don't make 2 points, don't make 3 points, one strong point, your blinding point.
And to the point of being able to assist you to make a rebuttal if an opportunity comes up, when the other side's making a submission, it's always a good idea to take notes of what they're saying. And if something pops up, write it down, save it for your rebuttal.
Yeah.
Maybe pass a sticky note to your co-counsel. Do you agree we should rebut on this? Yes. Okay. So now you've got it in your back pocket for when you have your opportunity to rebuttal.
All righty. Well, look, that concludes all the information we had, and we had to speed through that because it's taken a bit of time because we had Luke and questions. But look, I think in the context of it all, I think the main things is, one, remember the theories of advocacy. And the theories, again, is you want to persuade, you want to win. It's a legal conversation, not a legal presentation. And know your file inside out and know the law that you're referring to, know the cases, because you'll get asked about the cases you're referring to. What's that case about? How's that relevant? And you want to be all over that so you can present and give that confident submission. You don't want to write out your submissions. You want to be dot pointed and you don't want to read. That's very important. Also, the other important thing is just understand the significance of the court that you're appearing in front of. Give it the respect it deserves. Yes, like I've said, law is old school. It is very traditional, but that's what the courts are, and you just got to respect that. And you're not going to get much love if you're not giving it the respect that it deserves. So there was a lot to go through. I think we tried to squeeze in as much as we could. We heard from Rob. So yes. So has anybody got any questions? Actually, the last thing we should say is at the end of the submission, once you've summarized, the way to conclude a submission is simply to say, if it pleases the court, if Your Honour does not have any further questions, or if I cannot assist the court any further, that concludes the applicant or that concludes the respondent submissions. And then you sit down. Okay. So that's the way you would summarize it. Nice, neat, finish, clean.
Thank you very much, Kurt, Mark. It's been nearly 2 hours of the session. Went a bit beyond the time limit, but certainly very helpful information throughout it all. So I'd just like to remind everyone just at the end, But if you are now interested, from Kurt Mark's recommendations in participating in our moots competitions now, we do have our witness examination and our criminal law moot that are coming up. And if you do want to join in on the witness examination, which is sponsored by the criminal law firm Starry Norton Halfin, you can find it at the link again at the chat that I provided. I'll let Kurt Mark take any questions that anyone wants to put forward. Then at the end of that, we could probably call it a night.
I think just what Mark and I really want to get across as well is the moots are a great opportunity to really practice your legal skills. You know, like I said, we've never been asked to write essays in practice, never been asked to do an exam in, you know, an hour and a half, 3 hours, or 3.5 hours, goodness me, the other days. You don't get asked to do that. The court submissions, yes. Written submissions, yes. And the ability to take legal principles, take facts, and apply them in a practical sense as the moot requires you to do is very important. And it's just a great way to build on your skills as a legal practitioner or as a soon-to-be lawyer, and you can put moots on your resume because it's an important experience to have undertaken whilst at uni.
And to that point, you know, even though I'm in the commercial space, my boss is a lawyer. He and so when he saw that on my resume, he was quite impressed that I'd done some moots and I'd done, you know, the internships and the clerkships and stuff that I did during uni. So it does, it all adds up at the end. The more you expose yourself to, the more experience you get, the more you kind of apply yourself to, in the case of these moots specifically, treating them as though they are real world cases and that you are the lawyer, the more you're going to get out of it. And the more you get out of it, the better you're going to be. And it's great to see everyone, you know, here. You guys want to take that next step, and that's really important. So well done for showing up and being a part of this and wanting to take advantage of these opportunities. It's really great.
And look, you know, if you honestly, to be completely honest, if you think just doing your degree and getting good grades is going to be enough to get a job after law school, it's just not. There are too many law graduates, and you got to remember, anyone who does a law degree is pretty clever, and to get through the law degree is hard. It's not easy. It is not an easy degree. And if you think it's easy, you're probably not studying hard enough. And so you just got to build your resume beyond just studies. Yeah.
And depending on where you apply for a graduate role, you may have to submit an academic transcript. But the reality is, in the context of the professional world, no one's going to ask, you know, what you scored at uni.
No.
Doesn't matter.
Nobody's going to come to you and go, oh, what was your WAM, Kurt?
No.
But look, when you do apply, your grades are important. Don't get me wrong. You know, you need to get good grades, but the application and job process is more than just grades. It is how good are you as a well-rounded lawyer, because law firms are not interested in somebody who's purely book smart. They want somebody who is agile, able to adapt, work on their feet, and you show that through moots, you show that through work experience, you show that through various experiences other than opening up your textbook and doing the readings for block 1, 2, 3, or 4.
Yeah. Real world experience helps you develop that common sense as well.
Yeah. Now, we got any questions?
Covered them pretty well before, I think.
Okay.
We did have 25 minutes of questions. I guess everyone's exhausted then.
That's all right. That's good. Well,
thanks heaps, guys.
No worries.
No worries.
There's no further questions. I think I'm going to head off, and I think Mark will head off too.
That was great, guys.
Thank you very much to every student who's come and participated. I really do appreciate you guys taking the time out to attend this event. And thank you very much, Kurt and Mark, for providing it.
No worries, anytime. And look, you know, if you ever got a question, happy to help. But look, the fact you've taken 2 hours out of your time today to be here is commendable and shows that you're on the right path. And good luck with your studies. Uni is 4 or 5 years or 3 years. however long it takes you. It took me 5, but it's the best time. It's great. Make the most of it. Go to the dictum events. Do the moots. It's good fun. It's great.
Thank you.
Thanks, guys.